Okay, I have 12 o'clock Eastern time, or for those in Italy, 6 p.m. It's
Yes.
dinner time.
No, for 2 more hours at
2 more hours
least.
for dinner time. There you go. People are continuing to dribble in, but as you can see, if you're logged in, this is being recorded and it will be available from the George Washington University on its YouTube channel. So you will be able to access this afterwards today if for some reason you have to log off a little early. So welcome to today's webinar. It's sponsored by the University of Bologna, George Washington University, and the American Bar Association's International Law section. The substantive part of our webinar will run for about 1 hour, but then we're happy to stay on and take questions. You can feel free to post questions in the chat, but we may not answer them till the end. And of course, we're not answering any case-specific questions today. Today's webinar is focused on a complex private international law issue, and that's custody jurisdiction. Increasingly, parents move their children across international borders, sometimes without the permission of the other parent or a court. And of course, there is an existing treaty, the Hague Abduction Convention, that focuses on promptly returning an abducted child so that child is presumably back in their home country so the parents can then resolve custody of that child. In other words, the Hague Abduction Convention is an anti-forum shopping law. It does not, however, resolve where the parents then go to litigate custody of the child. There's a complex weave of laws, another international treaty that all impact custody jurisdiction. So for today's webinar, we have included experts in private international law from the United States and Italy. Now, why the United States and Italy? Because the last two Hague Abduction Convention cases that were heard by the US Supreme Court, of only 5 that have been heard overall, were of children abducted from Italy and brought to the United States. And clearly there was litigation in both of these cases under the Hague Abduction Convention. That's how it got to the US Supreme Court. But there was also litigation on the periphery of those treaty cases related to the children's custody. And so therefore, that's the focus of our discussion today. Where does one go to litigate custody? How do ongoing proceedings under the Hague Abduction Convention impact the custody litigation? And how might that have played out under the facts of the 2 Supreme Court cases that we're going to focus on today? So I'm going to introduce my panelists here. I welcome Professor Michele Lupoi of the University of Bologna. He's written extensively in transnational litigation, cross-border jurisdiction, and procedural family law. He's joined by Dr. Esther Di Napoli, an Italian-Spanish attorney based in Italy and an adjunct professor of the University of Ferrara. On the American side, I'm joined by Ashley Tomlinson, an attorney in Houston, Texas, board certified in family law and a fellow of the International Academy of Family Lawyers. And I am, for those of you who don't know me, Melissa Kuczynski. I'm an international family law attorney based in Washington, D.C., and I'm an adjunct at the George Washington University School of Law. So before I start interrogating these amazing attorneys, I want to give our audience just a few of the salient facts of the 2 US Supreme Court cases, because that sort of founded the foundational components of what we're going to discuss today. So in 2020, the late Ruth Bader Ginsburg wrote the opinion in the case of Monasky versus Taglieri, which is the case of an American mother who removed the party's infant child from Italy and brought that child to Ohio. The father sought recourse in various courts in both Italy and Ohio, as is the case. These cases have multiple court cases in multiple countries and multiple courts. With the mother absent from the proceedings, an Italian court granted the father's request to terminate her parental rights. In Ohio, the father then petitioned the federal court, the US District Court, for return of the child to Italy under the Hague Abduction Convention. The district court granted the father's petition after a 4-day bench trial and ordered the child's prompt return to Italy. So in December of 2016, the child, nearly 2 years old, was returned to Italy and placed in her father's care. In the United States, the mother proceeded with appeals, taking the case to the US Supreme Court. The ultimate issue there was habitual residence, but ultimately the result in the Supreme Court didn't reverse the return order. The child is in Italy as we speak. The second case is perhaps even more heavily litigated. In 2022, just last year, Justice Sonia Sotomayor wrote the opinion in the case of Golan v. Saada. which was the case of an American mother who retained the party's young child from Italy in New York at the conclusion of a family wedding. In September 2018, the father filed in Italy a criminal complaint for kidnapping and initiated civil proceedings seeking sole custody of the child in Italy. The father also petitioned under the Hague Abduction Convention in the federal courts in the Eastern District of New York, seeking an order for the child's return to Italy. The district court granted the father's petition after a 9-day bench trial. The mother appealed. Ultimately, there were several return orders, several appeals, and it made its way back up to the Supreme Court. And meanwhile, the parties also sought recourse in Italian courts. So there was a domestic violence protection order that was obtained at the request of the judge in the Hague Abduction Convention case that would require the father to stay away from the child upon that child's return to Italy. The mother had previously filed a custody case in New York, which was dismissed, and there continued an ongoing custody case in Italy with a lawyer appointed for the child, a trial date that kept, of course, getting pushed out as the Italian courts waited for the order returning the child. So as you can see, overall, there were multiple lawsuits filed in more than one court in more than one country in both cases. But to distill that for our discussion today, there were Hague Abduction Convention cases filed in the US federal court, and there were custody cases filed in Italy, aside from all the criminal cases, protective order cases, and those type of cases. So that is where we start our discussion. There's complicated, nuanced litigation in multiple courts in multiple countries. In both of these cases, under the Hague Abduction Convention matters, the child's habitual residence, which is a prerequisite to returning a child, was found to be Italy. So in Monasky, the child was returned to Italy. In Golan, the child had been ordered returned to Italy several times. The case is now in a new posture. It's still waiting to be resolved. So I'm going to start by asking Esther and Michele, when would an Italian court have jurisdiction to decide custody of these two children in these two separate cases?
Thank you, Melissa. If Michele allows me, I would start. And so good morning and good afternoon for those who are attending from this other side of the ocean. You've mentioned already the key notion, the habitual residence of the child. And let me first say that in most family law cases having cross-border implication, Italian courts become European courts. And so the rules on jurisdiction aimed at designating the competent judge are European rules, applying despite the fact that one party or the child himself or herself have significant connections with the third countries. It doesn't matter that they are European parties. And in this case, like the US, so significant connection with the US, of course. And in particular, since the 1st August 2022, a regulation, so-called Brussels II-TER, Regulation 2019-1111 on jurisdiction, the recognition, enforcement of decisions in matrimonial matters of parental responsibility, and on international child abduction apply. And this new regulation replaces the previous one, the so-called Brussels II bis or 2A regulation. And it's chapter 3. It's the real big novelty. And it applies only to what are called the intra-European international child abductions. So that is when a child is wrongfully removed or retained in a member state other than the member state where he or she was habitually resident immediately before the wrongful removal or retention. So this regulation sets forth clear rules on coordination between the regulation itself and the 1980 Hague Convention, which the regulation complements. And there is a rule on jurisdiction in matters of parental responsibility in cases of the wrongful removal or retention of a child. It's Article 9 of this new regulation. And this article states that the courts of the member state where the child was habitually resident immediately before the wrongful removal or retention shall retain their jurisdiction until the child has acquired an habitual resident in another member state, adding conditions that need to be fulfilled in a cumulative manner. So if the two custody proceedings were to start today in these two cases, The rule on jurisdiction coming into play would be the one contained in Article 7 of Brussels II ter, which relies on the principle of proximity and places the habitual residence of the child at the very center. If the child is habitually resident in Italy, at the time the court is seized, the Italian court shall retain jurisdiction. So like habitual residence, the notion of habitual residence itself and all expressions contained in all European regulations are to be interpreted in a European way that is looking at all the possible definitions that the same European legislator has given in the regulation, but also in the looking at the interpretation delivered by the European Court of Justice of in absence of a clear definition of it. Even the expression of at the time the court is seized has to be interpreted uniformly in a European way. And so if on one side I was saying there's no definition of habitual residence, as we will probably see, it's the key of our discussion. So the European Court of Justice has been delivering many judgments that are also mentioned in the two cases we are looking at today. On the other, there's Article 17 of Brussels II ter regulation that clearly tells when legal practitioners shall understand, when the court shall be deemed to be seized. So but looking at in 2016 and 2010, when custody proceedings in those respectively Monasky and Golan cases took place, the Italian judges should have declared jurisdiction according to Article 2.8, of Brussels II bis regulation, which sets forth the same child habitual residence rule. And let me just conclude in a very maybe more general way that there's also an article, a disposition contained in the 1996 Hague Convention, which we will probably look at also, which has been ratified in 2015 and which the US have not done so yet. And Article 7 also contains, of that convention, also contains a special rule on jurisdiction in matters of parental responsibility in child abduction cases, which is similar to Article 9 of the Brussels II ter regulation. But however, that disposition does not apply due to the disconnection clause which comes into place. And so Brussels II ter overcomes the convention and applies otherwise. Thanks.
And if I may add something to what Esther said, indeed, today, from a practical point of view, Italian courts would rule on custody of a minor as long as the minor is habitually resident in Italy. And interestingly, even if the child is habitually resident outside of the EU, take the US, even if through ordinary private international law provisions of the Italian legal system, habitual resident would not necessarily be the connecting factor. Still, the Supreme Court constantly, by referring to international convention, basically said if the child is not habitually resident in Italy, and even if the EU regulations do not apply, we still will not exercise jurisdiction. So habitual residence is the key. Of course, there is one, in the context of abduction, there is also one other element to consider, which is the fact that when you remove a child from his or her habitual residence, of course, it is not anymore physically present in the state of origin, say Italy, in the cases that we are taking a look at. So, but then within the regulation 1111, which Esther mentioned, there is a specific rule, which is Article 9, which basically prorogates the jurisdiction of the country of origin, the original habitual residence country, for a period of 1 year, which coincides with the 1 year time limit for bringing a Hague Convention case. So that also has to be considered. As Melissa, you correctly said, the Hague Convention tries to fight for shopping, and Article 9 is instrumental to this policy.
That goes exactly to the next question that I had, and that is, when do you file these custody cases? It sounds like both the fathers in these cases filed their custody cases in Italy quite promptly, and almost simultaneously or proximate to when they filed their Hague Abduction Convention cases. Assuming the Hague Abduction Convention case is going on, and it may not go quickly in the United States, depending on what courthouse and what judge is able to resolve it, can the case in Italy, the custody case, proceed? Or will your judge pause that case? Is there a strategy behind when you file your custody case in Italy? Should you wait for the Hague case to be resolved? Should you file it promptly? Will it get resolved simultaneously?
I wouldn't say there is necessarily a strategy. I mean, from a very practical point of view, it mostly depends on the money. Because a Hague conference case, if you go through the central authorities, you basically don't have to pay for the proceedings, while if you bring custody proceedings, of course, you have to find a lawyer and pay for the lawyer. So that's a very practical reason. I spoke to some people and they were reluctant to start custody cases for this very pragmatic reason. But other than that, there is no lis pendens between the two proceedings. And basically, the judge of origin will not be bound by a decision in the country of refuge. There are specific rules within the EU member states which basically give to the judge of the country of origin a dominant position. It can somehow take this with a hint of salt, overrule, for example, a decision of non-return from the judge of the country of refuge.
So if a US judge in one of these cases said, the United States is the habitual residence, your Italian judge could say, no, Italy is the habitual residence and proceed with the custody case?
Yes, but then at that point, we would have a clash, a conflict of judgments, which would eventually lead to a situation where you have an Italian judge, which is useless if the child is no longer in Italy, which will not be given recognition and enforcement in the US. So from that point, another very practical aspect,
it is.
The race to the courthouse and the race to the judgment has implications.
Interesting.
If I may add, yes, from also a very practical point of view. So first, I would say the time is of the essence. So if you have money enough to start custody proceedings, would be even before an abduction is carried out, that could avoid because asking also for custody and also relocation, for example. But let's say that the abduction has taken place. I've seen, and that's very sad, that Italian judges might, and very often do so, they might subordinate their jurisdiction in custody proceedings to the child's effective presence here in Italy on the Italian territory, and which might be very difficult if the child has been taken or retained abroad. And even if the child's present, as we know, it's one of the elements to take into account when evaluating where the habitual residence of the child is. The Court of Justice clarified that habitual residence does not only mean presence. So this is a problem of Italian judges, and I've seen that quite often. I don't know if Michele can agree. I don't know.
Yeah.
So I wanted to then shift to Ashley, because we're using the words habitual residence. We're using it in terms of jurisdiction for custody in Italy under Brussels Tutelle. We're using it in terms of the Hague Abduction Convention, two separate ways. How would the courts in the United States assume jurisdiction over these two children? I mean, in their situation, is there a chance that they could assume jurisdiction? Under what circumstances? What is the typical rule here in the United States?
So here in the United States, 49 of the 50 states will determine jurisdiction under the UCCJEA, which is the Uniform Child Custody Jurisdiction and Enforcement Act. And similar to the European regulations, there is jurisdictional preference established by that statute, by that uniform statute. But we call it home state. And the UCCJEA has a jurisdictional hierarchy, with home state jurisdiction given a very strong, almost absolute priority over every other jurisdictional basis that exists under the UCCJEA. So if we're talking about an initial custody determination, meaning there are no other prior orders,
right,
then a state here in the United States will have jurisdiction over a child if that state is the child's home state. And unlike the convention, where habitual residence is purposely left undefined, home state does have a definition under the UCCJEA. It's the place where the child has lived for 6 consecutive months with a parent or a person acting as a parent. For a child that's under 6 months old, it's the place where the child was born. And that home state jurisdiction exists up to 6 months after that home state status has ended. So if a custody suit has been filed within 6 months from when home state ended, and there's still a parent living in that state, then it has home state jurisdiction, and it can issue an initial custody determination. That is a very clean scenario, which was not the case necessarily in these 2 sample cases that we're discussing. There were simultaneous proceedings and or existing orders. So in that case, the UCCJEA very clearly states that a U.S. state, even if it has become the home state of the child, a U.S. state cannot exercise jurisdiction if there's a pre-existing order unless other conditions have been met to modify that foreign order. And if there's no pre-existing order, but there are simultaneous proceedings that are already in existence in Italy, then the U.S. state court is going to have to dismiss the proceedings if the Italian proceedings are in what we call substantial conformity with the UCCJEA. So if for example, the Italian court has seized jurisdiction of custody before the U.S. court, but not in a way that we consider in substantial conformity with the UCCJEA, then we don't consider it a simultaneous proceeding that would necessitate dismissal of the U.S. custody proceeding. Even if it's the Italian case has been brought in, in pursuant to all the Italian procedural laws. If the U.S. state says this is non-substantial conformity with the UCCJEA, you lost what we would consider home state jurisdiction. So we will now take up the issue of custody in our court.
So in other words, at the time that both fathers had filed the custody lawsuits in Italy, we considered Italy to be the home state.
Yeah. So in these 2 cases, the fathers filed within that 6-month window after the child had left Italy. And so we would consider those lawsuits in Italy to have been filed in substantial conformity with the UCCJEA. Therefore, we're going to treat them as the court of continuing jurisdiction.
And even though if they had not filed within that 6 weeks or 6 months after the child had been removed, and they'd filed a Hague Abduction return case, I mean, is there an argument that perhaps they're just temporarily absent from their home state of Italy pending the resolution of the Abduction Convention matter?
You can make that. It's not a clean argument by any means.
No. Nothing is. That's why we have jobs.
I would, in Texas, under Texas jurisprudence, we say that intent should not be relevant at all to the issue of home state. It's based purely on physical presence. And so I would think that that would be a hard sell on the temporary absence. Now, I think the more fruitful route would be to say, okay, yes, the child is here. Yes, this is the child's home state, but you, state court, are required to decline jurisdiction because the child is only here by reason of what we call unjustifiable conduct. That home state jurisdiction only exists by virtue of the abduction. And so therefore, under the UCCJEA, you are required to dismiss this lawsuit. Now, the commentary to the UCCJEA says that fleeing domestic violence is not unjustifiable conduct, even if the act was illegal. It is not unjustifiable conduct for purposes of that specific provision. So, you know, we're back to
right. All the legal arguments that we need to make.
Yeah.
I mean, and what's been interesting is our Italian counterparts here have articulated that, you know, the Italian judge does not need to adhere to a finding by a U.S. judge of habitual residence in a Hague Abduction Convention case. Let's say in one of these cases, our U.S. judge determined Italy's the habitual residence, but for some other reason, we're not returning the child to Italy. How does that impact whether a U.S. court, now the child's sitting here in the United States,
right,
could the U.S. court just take up jurisdiction?
the U.S. state court.
State court, yes.
Yes, they could. You know, if the child has not been returned pursuant to a Hague case, there's no requirement under the UCCJEA to enforce. There's no return order to enforce. A return order under the Hague is enforceable as a custody determination pursuant to the UCCJEA. If there is no return order, and there is home state jurisdiction, and there is reason for this court not to decline jurisdiction, then the court can continue with that custody case.
So what if the Italian courts were seized of jurisdiction while they were the home state, and they are saying, we're proceeding, child's not back here, but we're going to continue proceeding with our case? Do our courts have to go through any type of rigmarole or process before they would assume jurisdiction?
So that's before they assume jurisdiction. Yeah. So if there has been a foreign custody order that is entitled to recognition, that is in substantial conformity, then yeah, the state court could not continue with that custody suit unless it has either jurisdiction to modify, which includes, you know, if the Italian court declines jurisdiction, if the Italian court finds that this is a more convenient forum, and alternatively, if nobody's in Italy. If nobody's in Italy, then our courts can proceed. You know, and this situation also highlights the fact that you can win the Hague suit, but ultimately still lose the custody battle, the jurisdiction battle, because let's say, like you said, there's a habitual residence finding, Italy is the habitual residence, but the child is not sent back because of one of the exceptions to the mandatory return requirement. But there is a Italian court order that is entitled to recognition under the UCCJEA. Instead of filing a Hague return action, that left behind parent can then file an enforcement under the UCCJEA. An enforcement of a foreign order under the UCCJEA that has fewer defenses available to it than under the Hague Convention. You don't have a grave risk exception. You don't have a well-settled exception. The US court is required to enforce that foreign custody order if it was issued with notice to the other parent, if it is still a valid order, if it hasn't been modified or vacated. And so these are, you can win the Hague case, but ultimately a state court can still order your child to go back to Italy. And under the UCCJEA, you have an expedited enforcement mechanism where a court can actually order the law enforcement authorities to go and take physical possession of the child and have that child appear in court the next day for purposes of basically a return order.
So we're getting into some conflictual terminology. So Michele, what are your thoughts on this?
This is very interesting. And if I may add something to it, it is extremely true. The Hague case is very important, of course, to have the child brought back or have the child staying in the state of refuge, so to speak. But still, the custody proceedings prevail even in the very same state which gave an order of no return. Because maybe there is no ground to bring the child back under the Hague Conference, but the Hague Convention. But on the merits of the custody case, even a US court could say, well, we grant custody for the parent who lives in Italy, and then the child has to go back to Italy. So it's a different situation from the one Ashley talked about, but still we have to take that into consideration. That also means that a party has to defend himself or herself in any situation, in any judicial proceedings, because you never know what can happen. And
I think that's right. And this, when you talk about the Hague Abduction Convention matter, that really is just situating a child physically. That is not the real crux of what's going to happen. That's the custody case, which is why custody jurisdiction is so vital to this discussion.
It's a provisional remedy, so to speak.
Yes. Yes. It's a temporary situating of the child. So we've been talking about home state, and Ashley was describing the very concrete definition. So I'm going to go back to Michele and Esther and talk about habitual residence, because you talked about it in terms of jurisdiction, and you talked about it in terms of the return requirement under the Abduction Convention. What really is habitual residence? What are the connections that require under your law to establish it?
It is very slippery, Esther, no?
Yes, it is.
I mean, everything counts, like Depeche Mode would sing in the 80s.
It's true, and it needs to be assessed on a case-by-case approach. So Ashley was talking about a 6-month duration period. We should, in order to apply to interpret what's habitual residence under the European law system, we were talking before, the duration counts, but it's not the main element. So among the objective elements, there's a lot more. And this a lot more has been detailed by the European Court of Justice, which hasn't given, again, any definition, as no, the Hague Conference has done so, but has uniformly defined and designated the elements that one should look at when identifying habitual residence of a child. And since 2009, we've been the Court of Justice has been delivering a lot of decisions on the definition and clarification of habitual residence in that specific case. So among other things, the school, the doctor, anything, the duration, the presence of the child in that territory, the language, anything that can prove that the child has a certain degree of integration in that specific place, in that specific state. And the intention, does the intention count, the will? Ashley was saying no on that, on the US perspective, but from the European point of view, the Italian judge, who's actually perfectly applying the case law of the Court of Justice, needs to look at also the element of the subjective element of the will. So it's not an interior will that cannot be demonstrated, but it has to be objectively demonstrated. But it's still the intention of the parents in this case, if the child is not, children, then that's another thing. I'm going now in a second to that. But so the will, it's important, but it's not the element, is among the elements, like citizenship. It's not true that citizenship doesn't count anymore. It's still important, but needs to be looked at as one of the elements among all the others. So intention counts. The Court of Justice has been also giving interpretation, clarifying the elements in order to categorize habitual residence of different kind of children. Infant, and we have mercredi, and we have even older children, depending on the degree of maturity of such children. And depending on their degree of maturity, you need to look at what the parent or the holder of parental responsibility is effectively doing in exercising his or her parental responsibility. And let me just say that our courts are very much in line with the interpretation given by the Court of Justice. And recently, well, in November 2022, the Supreme Court delivered its last decision on the identification of habitual residence, and looking at, it was an intra-European abduction, but still that would be applicable also in extra-European abduction cases like the ones we are looking at.
Yeah. If I may add on that, there are, I think, just 2 or 3 clearly defined ideas. The first idea is that in order to have habitual residence, a child must at least have been physically present in the state. This has implications for children who were whose parents were living, for example, in a country, then the mother got pregnant, moved to another country, the child was born there and never returned. There have been cases where the father would say, well, but we intended to live in Italy. There's an Italian case decided by the Court of Justice. And the court says, well, we can't have habitual residence simply based on the intention. So you have to be at least physically present in Italy, for example, for 1 day. On the other hand, I think that what Esther just said implies that given certain conditions, a child can acquire habitual residence immediately upon entering into another state. Basically, when a family burns the bridges behind herself, they move to another country, they buy a house, they send the kids to school. 1 day is enough. You have, so it's rather different from the home state idea which Asha was talking about, I guess. And on the other hand, and then I stop, you can't have 2 habitual residences. I came to a different conclusion when I was writing about it, but the Court of Justice said no, you can't. You may only have 1.
They disagreed with you?
Well, they disagreed with me. Yeah, I was disappointed.
I mean, not everyone is correct, right?
I cried for a while.
They should listen to you next time. So going on this, so there could be an American father, an American mother, an American child who all relocate to Italy and immediately establish habitual residence there and might have to resolve their custody matter there.
Yes, but not necessarily so. Because sometimes when you move, you do that in an attempt to rekindle the flame, if you know what I mean.
Okay.
This happens a lot.
So intention, as you were saying, is part of the overall. So
I moved to Italy with my husband, for example, or with my partner because he or she lives there. But we say we are in a rough time of our life, and I say, well, I come with you and we see how it goes. So I wouldn't immediately.
Nice muddy waters that we deal with.
So sometimes just an email makes the difference, depending on what you wrote. Okay, it's okay for you to stay in Italy, but then you come back. Or it's okay for you to stay in Italy, full stop. That makes a lot of difference. So people today write a lot, maybe write things that they then regret. WhatsApp,
That's true.
emails, and everything will be used against you.
Everything is Exhibit A in your custody or Hague Abduction Convention case, for certain. Now, Esther, I think earlier when we were discussing, you were mentioning the 1996 Hague Child Protection Convention. And you correctly stated Italy's ratified it. The United States has not. We signed it in 2010. We have not ratified it. Of course, the UCCJEA that Ashley has referenced has actually been updated. It was updated in 2013 on the anticipation that we will eventually ratify it, and that's how it will be implemented for custody cases in the United States for purposes of jurisdiction. But how does the 1996 convention at all play into our discussion today?
Actually, well, it's true that in Italy, the convention was ratified in 2015, entered into force on the 1st of January 2016. It has barely been applied, let me say. It's true that we do have a good number of decisions issued by the Supreme Court. The number is 6 since 2016. The first is in 2018. The last one is this year, two decisions in row, which in my view gives the impression to legal operators about the need that we want to apply it. We still don't know how to do it, but we are working on it. In these situations, in the Hague Convention, the 1996 Hague Convention plays an important role on the one side because it's a preliminary issue. It from the Italian perspective, it's applicable. It contains also conflict of laws rules aimed at identifying the law applicable for the establishment of parental responsibility. And the habitual residence, again, of the child comes into play here. So in order to understand whether international child abduction has taken place, you need to understand whether the person abducting the child abroad is holder of parental responsibility. And in order to do so, going back, you need to understand under which law that is decided. And if you have your habitual residence in Italy, Italian applicable law would decide over parental responsibility. And this on one side, on the preliminary issue about parental responsibility and who holds parental responsibility among parents. Parents, even if parents are not married, they will hold both parental responsibility. So on the other side, there's this Article 7 I was mentioning before, which is actually mirrors Article 9 of Brussels II regulation, Michele and I were mentioning before, setting forth a disposition on custody proceedings, it's a rule on jurisdiction on custody proceedings in case of parental child abduction. But as I said, this article doesn't apply because our Brussels II regulation applies instead.
Okay.
So just to mention at the very end, an important thing under this convention is the functioning of central authorities. And this is also why it's good to ratify it among other things. One thing on the Italian perspective, is that the central authority under the 1996 Hague Convention is not the Ministry of Justice, but incredibly is the Italian presidency of the Council of Ministers. And this is something very strange that has been pointed out and reported also by the Italian Authority for Children and Adolescents to the UN Committee on Children's Rights, because it doesn't have any sense. So
since you brought up the issue of central authorities, I'm going to skip a little in the notes that we have. And so I'm going to actually ask, for those who are here not knowing what a central authority is, it's essentially an office that is designated by a contracting state to a Hague Convention to help the implementation of that. And that's the very simplest form of it. And then there are central authorities under the Abduction Convention, central authorities under the Child Protection Convention, and they may have a role in all of this. And so I wanted to ask, what role would they have played in these two Italy-US cases, or what role could they play in a case like this? And I'm not sure if Ashley has any thoughts on this, but I don't want to put her on the spot. If she wants to start or defer to Michele Esther, I'm going to let her choose.
So your question is basically the role of the central authority,
right? Versus say a court or anything.
Okay. Yeah. So in this case where the child has been brought to the United States, the U.S. Central Authority will be on the receiving end of that Hague application. And at that point, the Central Authority can provide some assistance as far as locating the child, locating legal services. Unlike the majority of signatories to the 1980 convention, the U.S. does not provide those legal services. We do not provide funding for it. It is not a function of, the federal or state prosecutor's office. The left behind parent has to retain their own counsel, but the U.S. Central Authority will help the left behind parent locate, sometimes pro bono or reduced fee, legal counsel. And they can, they'll send the letter promoting voluntary return if requested by the left behind parent. But their function is rather limited. There's going to be the bulk of the work, the meat of the work is by these private litigants in the U.S. court system with private counsel. This is not going to be a function of the state prosecution of these
at
cases.
their own expense in the most cases, right? Yeah. So our central authority is just a sort of a repository,
Exactly.
A helpful resource, but not the end all be all. And of course, our implementing legislation. Michele was saying that there's this sort of 1 year that's out there under the Hague Abduction Convention. If you don't actually file your return request within 1 year, there are additional arguments that the taking parent might make or argue. And filing in the United States is not through the central authority. It's in a court. And so, as you were saying, our central authority doesn't have that authority.
And with that 1 year time frame in other jurisdictions, that 1 year is measured by the application that's transmitted between central authorities. Under U.S. jurisprudence, it's the filing of the lawsuit. Yeah. So even if a parent has sent an application to the U.S. Central Authority, if they have not filed the lawsuit, that you could still find yourself in trouble with that 1 year well-settled argument, which kind of illustrates the lack of role by that is taken by the U.S. Central Authority in our cases.
Mm-hmm. Esther or Michele, do you have thoughts on central authorities?
Maybe Esther has got more direct.
Well, actually, I had invited also our the head of our central authority under the 1980, but he was very busy, but he was very happy. He will be happy to watch us. Today, I think that the role of central authorities has been now renewed by Brussels 2-ter regulation. I mean, it's a fact, it's not my opinion, but because Article 25 of the new Brussels 2-ter regulation gives not just judges involved in international child abduction, but also central authorities, the obligation to inform parties about international cross-border family mediation. And this is a burden that is put on central authorities even bigger. And as you were saying, Melissa, even our central authority, it's under the Ministry of Justice. Now the 1980, I'm talking about the 1980, the 1996 central authority is missing in an office of the Italian presidency of the Council of Ministers. But our central authority under the 1980 Hague Convention is made of almost 5 people. and it's suffering a lot. It's working very well. We must say it's true. They replied quickly, but still they again have more work to do under this Brussels II regulation.
Yeah, Esther mentioned mediation, which is something which central authorities should, at least in theory. Ashley somehow gave a bleaker picture of the US situation, should play a role in ADR in this context. Apparently, from the data available, the majority of adoption cases are decided not through court order, but by some form of agreement, which is a good thing, even though one then has to look at the substance of the agreement. This might be more complicated. So this is an important idea. And today, within the European system, the European space of justice, I would say that this new regulation, on the one hand, makes the return of the child a less absolute policy. There are some corrections or limits to the principle of automatic return, but on the other hand, it implements or tries to implement the role of central authorities in dealing with this situation efficiently.
I mean, given the time, I do want to touch base with Esther about mediation, because you may have some things that are evolving in Italy that may or not, and they might not be evolving in the United States in terms of mediation and these cross-border custody child matters.
Yes. So to date, in cross-border family mediation purely, let's say purely internal family mediation is well established, and there currently we've had a reform of our justice system where family mediation has been stressed. So the legislator has been stressing on family mediation. However, there has been no mention to cross-border family mediation in the reform, but there's still something going on. We need to implement Article 25 of the Brussels II regulation, and that's an obligation we cannot escape. So I'm working within a project called EGN ITA, which is ITA aimed at strengthening the Italian dimension of the European Judicial Network, EGN, and it's aimed at building bridges between associations aimed at working within the field of civil judicial cooperation. And in this framework, we are going to launch in February next year the first course ever organized in Italy on in cross-border family mediation. And this has been made possible through the strong collaboration between many associations, and among them the International Child Abduction Lawyers Italy, which is an association I wanted to mention. I'm part of it, and it also a university, the University of Milan, the University of Genoa, and also Reunite, which is the International Child Abduction Center based in the UK, which has long experience in cross-border family mediation. So there, just to end up with this, there's a link on crossbordermediator.eu, which holds the list of cross-border family mediators in Italy, and the list is very poor. We only have 2 cross-border family mediators in Italy, so we need training. We need training to the sensibility and the particular skills that a cross-border family mediator needs.
I'm going to shift gears just a little, because we're talking about resources. We talked about central authorities. We talked about mediation. I'm going to ask Ashley about judicial communication, and I start with Ashley because our internal law has some interesting, robust requirements when it comes to judicial communication. And how does that work in these cross-border cases to help facilitate the jurisdictional components?
Yeah, so there's it's called the International Network, Hague judges, and they are there to facilitate communication when there's a question about, in a Hague case, about, ameliorative measures or undertakings, or whether custody proceedings can be implemented, and when and how quickly, the ability of the other country to issue interim orders, confirming the validity of prior orders that might be dispositive to the issue of rights of custody, prior factual findings that might be relevant to the case, like domestic violence findings, and even jurisdictional issues about what's going to happen. Is Italy going to keep jurisdiction? Is Italy going to transfer jurisdiction? So, a court can sua sponte, initiate that communication. What happens is you can send an email. There's an actual email address, and the Hague network judges between the two countries at play will communicate, and they'll decide whether or not the Hague judge will be the intermediary, or the two local judges will communicate directly. And so there are a lot of due process issues that come up with that.
That's what I was going to ask.
Yeah. So, how much of this is ex parte? How much of, we don't want, ex parte communications. We want the ability for both sides to be able to present their own legal arguments when it comes to the application, perhaps, of foreign law regarding validity of an order, or the existence of, protective measures that may or may not be at issue in a case. And so, there's these should be, there should be a record of these communications, and there should be an opportunity for both sides to participate in these communications.
Interesting. Would Michele or Esther, if a U.S. judge called an Italian judge, would the Italian judge pick up the telephone?
He will, but probably with English. I don't know if we'll be easy now. Sorry. No.
It might be a complicated conversation, but yeah, but basically that what might happen, at least within Europe. The judicial network is very informal, which poses problem of due process, actually. Okay. But basically the idea is that a French judge might possibly, through central authorities or points in the network, get in touch directly with the Italian colleague, and vice versa. Yeah, things are getting very easy with technology also. Yeah, that's true.
I mean, it is fascinating, because our UCCJEA does provide for, during certain simultaneous proceedings, for our judges as a mandate to contact the counterpart in the other jurisdiction. And when a court in another jurisdiction, a judge won't pick up the telephone, that becomes complicated for us in our court cases. And Ashley is exactly correct that our judges have now learned of the value of the International Hague Network of Judges, and how that could potentially help facilitate. Of course, that's the custody component in the Hague Abduction Convention case. We're not using the UCCJEA in the United States. And so there isn't a process, a statute that says this is how the direct judicial communication should go to protect due process and whatnot. And so there have been cases recently where a judge might pick up the phone and call, the U.S. central authority, outside of the actual hearing, and be connected to the foreign central authority to gather information about ameliorative measures or whatever, protective measures, whatever it might be. So it's very interesting. I mean, we're at the hour. We said that we would go over by up to a half an hour. I don't see any questions yet. If people have some questions, please pop them in the Q&A and the chat. But failing any questions in the next couple minutes, I think I have just another question about enforcement for all of you, since I have you all here. Ashley described how relatively straightforward it is to take a properly, issued or a substantial conformity, Italian custody order, and bringing it to the United States and having it registered and enforced under our UCCJEA. If a U.S. court issued a custody order, what are the prerequisites for an Italian judge recognizing and enforcing it?
Esther, you or I?
Go ahead, please.
Okay. Well, basically, we do have, of course, a statute on private international law. The U.S. judgment is from a third state, so no EU regulations. It's a statute going back to 1995, number 218. It was at the time, it was pretty revolutionary from a certain point of view. It basically granted very easily recognition and enforcement to foreign decisions. There is a specific provisions on foreign decisions concerning family relations, which is Article 65 of this statute of 1995. And it basically says that the foreign decisions concerning family relations or personality rights will be recognized without any proceedings or exequatur if they are given by the authorities of the state which applies the same law which would be applicable under our private international law rules. That's the rule. There are other possibilities. The only limits are public order and the right of the defense. I guess you would call it due process. Mm-hmm. So when it comes to family relations, the possibility to import foreign decisions are larger than ordinary civil and commercial matter cases, because in civil and commercial matter cases, Article 64 comes into consideration. And that provision only allows for the enforcement in Italy of judgments, so decisions who have the formal requirement of a judgment, which have become res judicata. Now, res judicata has very different meanings in Italy and in the US, but basically we would define res judicata as the finality, the impossibility to review a certain decision under appeal. So a custody order who is still appealable, or which does not have the formal requirements of a judgment under Article 64 would not be recognized. Under Article 65, I would say that it would, because the technical words are different. Article 64 talks about judgments. Article 65 talks about decisions, and in the law, at least from the Italian perspective, words matter. And if you change the words in the provision, the outcome is different. I don't know if Esther shares the same ideas.
Yes, and I must say that once the US have ratified the 1996 Hague Convention, everything will be very easier. Yeah. And even in the future, it's going to be easier for to recognize and enforce. And let me just add to what Michele has just said, that in order to enforce a decision, it's if an enforcement is needed, because recognition is let's say automatic. There are some grounds for non-recognition, as Michele said, but if you need to enforce it, then you need some Italian action before the Court of Appeal. So if something needs to be done in action, that's the place, according to Article 67, sorry.
We had a question in the Q&A, and it related to, we're talking about Italy, US, and recognition enforcement between those two countries. is that the same if it were between two EU member states, say Italy and France?
Even more so, yes.
Yeah, exactly. Like as we were saying at the very beginning, habitual residence is key, and from the Italian perspective is looked at as a European notion, a European element, and it doesn't matter whether the connections are between member states or third countries. Third countries means extra European Union, so it doesn't exactly the same.
Yeah, actually, within the European Union, there would be a stricter rule on lis pendens, parallel proceedings. There would be no the second judge would not have the prerogative to check on the first judge jurisdiction. It would simply have to stay the proceedings until the first judge has affirmed its jurisdiction, and then it would have to, the second judge would have to dismiss the case. So
exactly
stricter than in the relations with the US. The lis pendens provision with the US has more limits, so to speak, or more.
For those law students on, lis pendens, res judicata, I love that we're using all these words today. It's
Brocardi, they relate in.
Well, in Italy, we've been told that we can't use Latin any longer, and it's strange that we can use Latin with Americans.
You can absolutely. I go into my class every week, and I will use Latin words, much to the dismay of my co-professor. Yeah. And I think that's how it should be. So you can come and talk to me and use the Latin words all that you want.
Yeah.
In case any other questions are coming up, we have one more. Could you talk a little bit about legally mirroring a Hague order cross-country, particularly in the US? I'm not entirely sure what that, I mean, Ashley, do you have any thoughts? It says, could you talk a bit about legally mirroring a Hague order cross-country, in particularly the US? And I know there's a provision in the UCCJEA that we would recognize a Hague order, and that's typically because, you know, if a parent was ordered to return their child from Alabama, but then that parent goes to Texas, Texas would recognize and enforce that Hague order, returning the child nonetheless.
Right. And that's the only thing that really comes to mind.
So I think there might be a clarification. What if, and I'm going to reword the question. What if there are, say, there's a return order from a foreign country that has, say, undertakings, and the orders to return to the United States, or vice versa, from the US to Italy, and there's undertakings in there that a parent has to do something or does. How is that order dealt with? And so say Italy has a return order to return a child to Texas, where you are, Ashley, and the order says that the returning parent or the left behind parent sitting in Texas must do X, Y, or Z, must stay away from the other parent or something like that. And that's in the Italian Hague return order. What would Texas do with that return order? Can that be registered in the UCCJA when it's not a custody order?
Yeah, so I mean, that's the threshold issue. Is there, even if it's in a Hague case, is there a custody determination of some sort in that Hague return order? Is there something that is an interim custody determination? Because if it is, arguably it would be subject to enforcement under the UCCJEA. Which you would follow the normal recommended provisions for enforcement and recognition under the UCCJEA. But if there's no custody determination there, then enforcement of those other protective measures, ameliorative measures, is going to be very, very tricky. I mean, it's
as a matter of comedy. Would a Texas court say, okay, we're going to recognize it under temporary emergency jurisdiction? Or
yeah, I mean, you can ask the order to be recognized, but there's no legal vehicle for recognition of of that foreign order under the just general principles of comity, right?
Right, it would be under comity.
But the question is what enforcement mechanisms, even if it's recognized under comity, what enforcement mechanisms are available? Because it has to be a Texas order for it to be enforced. And if it's not registered, and it's just recognized under principles of comity, there really aren't any enforcement mechanisms there. You know, you can, if the child is in the US, and this is something that you could bring under temporary emergency jurisdiction, and have the court issue these temporary emergency orders if the child is there, and these ameliorative measures fall within the description of temporary emergency jurisdiction under the UCCJEA, that might be a possible route. I mean, do you have any other ideas as to how to enforce those?
I mean, I think you're right. The UCCJEA has registration and enforcement provisions that relate to custody orders. And per the actual language of the Hague Abduction Convention, Hague abduction matter is not a custody matter.
Right.
Or am I misunderstanding professors? You know, that is the question. I mean, let's look at it from the other side, though. What if it were a US Hague court that says the child shall be returned to Italy, but the father sitting in Italy shall not go near the child? What would an Italian court do with that Hague return order? Would that be enforceable?
Well, I wouldn't say in Italy it wouldn't be a problem of enforcement, because if the child is in the US, then it's the US enforcement authorities who have to get the child on a plane.
Yes.
Then when the child arrives in Italy, the problem is that are Italian courts bound by a foreign decision, which by US decision, which says, well, the child should not go near? So probably not necessarily an issue of enforcement, but mostly, I wouldn't say of res judicata for sure, because those are not decisions who have res judicata effects. They would be taken into consideration, for example, pending custody proceedings in Italy. Yeah, it's something I've never had to consider, actually. Very interesting. So I would say courts would tend to implement one way or the other.
And I do think that was an issue in the Golan v. Saada case. There are a lot of briefs filed in the Supreme Court that reference what we call undertakings. A parent voluntarily agreeing to undertake certain things once the child's returned or before the child's returned, which is a subset of overall protective measures, which was the real crux of the Golan v. Saada Supreme Court matter. And of course, the protective measures are just, what exists in the home country. Do you have a functioning court system? Do you have law enforcement that will come and address an issue if there's an emergency? The undertakings, everyone seems to have a lot of problems with those undertakings and whether or not they're enforceable or not, because some of the appeals in the Golan matter and some other subsequent Hague Abduction Convention cases in the US recently, the judges at the appellate level seem to think that the undertakings should either be enforceable or at least that the judge should have sufficient guarantees that the other side's going to adhere to those. And that could be the case. I mean, the judge might truly believe the other person's going to abide by whatever the court order says, separate from that.
And if I can proceed from the Golan case, the Golan case was about the ameliorative measures, right?
Yes.
And their impact on the return decision. It is interesting to point that that under the new EU regulation, basically there is no way you can refuse the return of the child if there have been ameliorative measures approved. That requires the national authorities to supervise those ameliorative measures. But the statutory provisions now go, are totally different than what the US Supreme Court said in the Golan case, as far as I understand it. We have a rule there. Sorry.
Ashley?
So I think I want to let Esther finish.
No, just go ahead. Go ahead, Ashley. Yes.
I think we do kind of have a rule under the UCCJEA too. It's not as clear cut as yours, but under the UCCJEA, a child custody determination is defined as anything relating to legal custody, physical custody, or visitation, and it includes temporary orders, interim orders. So if you have a temporary interim ameliorative measure that relates to physical custody or visitation, even though the Hague case is not supposed to be a child custody determination, I think you could possibly pigeonhole it into that rule that we have under the UCCJEA, but it's not going to be it doesn't sound like it's going to be nearly as straightforward and clear cut as it is under your EU provisions.
And what I just wanted to say is that these new provision under the Brussels II regulation fosters actually the return principle, that is because child abductions just try to do in a de facto way what it's not possible to do under law, because someone takes the child away to make that other judge be competent, or to ask that other judge issues about custody. So that instead should ask to the one of his or her habitual residence before the child abduction takes place. So the return principle here is even more stressed with this ameliorative rule, provisions rule, and this will strengthen the communication among the European judicial network, because judges will be bound to ask other judges what's going to be possible to be done in order to protect the child once the child has come back, has been returned in the member state of habitual residence.
Yeah. We had someone attending that was asking if you have, what is this new EU provision you're referencing?
Of course,
either Michaela or Esther might be able to post it for me.
I will. I'm now posting the regulation here.
But the specific provision
for judicial communication, I have that one that I will share.
I'm just sharing the link.
So I'll post that. If there are any other questions, if not, failing that, we have about 10 more minutes. So I wanted to give all of the panelists any final thoughts on how they have seen these cases overlap, the complexity, any problems they've seen arising because of all these simultaneous proceedings being filed, concerns that they've seen with judges handling these cases or anything to that matter. If anyone has any closing thoughts, I would love to hear those.
Now, I was looking for the specific provision I was referring to. Now let me post it online in the chat room. This is Article 27 of Regulation 1111, and you have to look at paragraph 3, where a court considers refusing to return a child basically solely for the excessive risk for the child. It shall not refuse to return the child if the party seeking the return of the child satisfies the court by providing sufficient evidence, or the court is otherwise satisfied that adequate arrangements have been made to secure the protection of the child after his or her return. So this is the specific provision which now binds European judges in applying the Hague Convention, which is basically what the US Supreme Court said that the US Court of Appeal could not do in the Golan case, right?
In the Golan case, the Supreme Court said that our judges have discretion to be able to review and assess ameliorative measures.
But on the other hand, here, as Esther was saying, this provision is in a global context where judges have to cooperate, collaborate, and basically agree or anyway discuss together protective measures, adequate arrangements. I would consider it very unlikely to have just unilateral decisions by an allegedly violent father. I mean, there should be some inquiry into the situation from the local authorities. Another interesting problem, which was evoked by Stephanie, I think that was the name asking the question, the mirroring effect. What if a child is abducted to the US? The US says, oh, bring the child back to Italy, and then the abducting parent takes the child from the US to Mexico. Is Mexico bound to enforce that decision? I mean, this is another issue I'll have to think about. Is that
right? Is it dependent on the fact that Mexico and the US are treaty partners under the Abduction Convention? What if they weren't? I know there's
because as you mentioned, the situation, this abduction situation imply a lot of proceedings, criminal, sometimes administrative, and then civil, and then in Europe you go to the European Court of Human Rights. A lot of abduction cases finally went all the way to Strasbourg.
Yes.
And they also imply sometimes multiple abductions.
No, that's true. That's the reality of some of these cases. So in the final 8 minutes, do my experts here have any final thoughts on the interplay of this? Is like it's a tangle, it's a web, it really is. It's a lot of lawsuits, and at least my observation is, and in a lot of these cases, unless you have lawyers that understand all of the moving pieces in both of these type of cases, they're going to necessarily file something in the wrong place, spend a lot of money and time doing it the wrong way, and then you have a mess. You've created a mess. So I mean, it's crucial to have someone who's versed in private international law. I mean, this is more private international law than it is family law in many ways, even though it touches upon family law. And that's my 2 cents. But any remaining thoughts while we have the three of you here?
If I may, what probably needs to be taken into consideration when dealing with child abduction cases, also from a legal perspective, but also from the perspective of parents, of the holders of habitual parental responsibility, is that what needs to be taken into consideration is the best interests of the child as the principle, the rule, the interpretive measure that needs to follow all steps. And so lawyers helping parents in deciding where to go way before child abduction happens. So need to be considering to consider the best interest of the child, that is, and the best interest of the child, that the child abduction as a fact is also considered under the UN Convention on on Children's Rights, and the children have the right, the fundamental right to still have contact with both parents, with both holders of parental responsibility if they don't have parents. And it's a fundamental right to keep contact with both of them, even if they relocate, if they move. So think about this, think about best interest of the child, even in child abduction cases. So that's my conclusive thought.
my conclusive thought is rather pessimistic, if I may. I would say that from my professional experience and from the readings of cases, unless you find some kind of settlement or ADR solution, the hard cases are lengthy, costly, and most likely ineffective, in the sense that enforcement finally fails. We've had some European law cases, where it proved impossible to remove a child from the country of abduction for reasons which sometimes are inexplicable, unless you have local bias into consideration. If you know, and I don't say anything more, because it's been this is going to be on the record. But there are a lot of variables to consider, and sometimes you may find that you win all of the court instances, but you never get your child back, and that's
I agree.
really frustrating.
You can win each battle, but not the war.
Yeah.
Ashley, any remaining thoughts for those who joined us?
I think, there's everything would be much more, simplified if the U.S.
I know we're
96 convention. But I think it's, for U.S. practitioners, it's really important to think about the interplay of private international law and the UCCJEA, and particularly how our concepts of home state conflict with principles of habitual residence, and what kind of complications that can create, or what questions arise. You mentioned temporary absence, and I kind of brushed over that, but because I think it's something that you can have an entire discussion about. Just, one CLE, just delving into that one topic. Habitual residence considers intent, physical presence. Home state is physical presence is dispositive, except when it isn't. Intention is irrelevant, except when it isn't. And so, it's and that makes the interplay between family law and private international law that much more difficult to navigate. And so I think it's a really interesting question for practitioners in this area.
And I think these conversations are to be continued. I think this was an amazing discussion amongst everyone that's here. For those who are still with us, I hope everyone found it engaging. The George Washington University School of Law's International and Comparative Law program will be posting the video of today on their YouTube page. And I want to thank Leah Calabro, who is not on our screen, but she's a professor at GW Law who helped organize today's panel and got us all here together today. So thank you, Michele, Esther, Ashley. Is it dinner time yet in Italy?
Yes.
Yeah, well, it's aperitivo time, which is even better than lunch.
There you go. Absolutely. Well, thank you so much, everyone. And I hope everyone has a good evening, dinner, lunch for Ashley and I. And I hope we can do this again with another topic.
Sure.
Perfect.
Of course. Thank you. Bye.
Bye-bye.
Bye-bye.
Ciao, everyone.
Thank you.